the Supreme Court had its oral arguments in the New York gun carry case, the first Supreme Court gun case that's likely to make it to a merits ruling in a decade. And the court, as you noted in your piece, tried to find perhaps something that's going to be even more important for the future of gun litigation in this country than whatever they rule on the actual issue. But the standard that should be considered by lower courts when they take on new gun cases in the future. Tell us a little bit about what the Supreme Court was pondering in that case. Tell us a little bit about who said what they wanted to know, and what they got as their answer.
So, yeah, as you said, multiple justices asked questions. Justice Gorsuch in particular made it a point to ask both Paul Clement, who was representing the petitioners, and the Solicitor General Fletcher, basically, how would you like us to review this law? There's no real standard. Do we do a traditional balancing test, intermediate scrutiny, strict scrutiny, where you're comparing what the state's interest is in this law versus the extent to which the right is infringed, or a text, history, and tradition test, which is sort of what they were leaning towards. It's what both Clement argued for, and it's what the U.S. Solicitor General argued for, where you look at the text. What does the text mean? Look at the history of the law and similar laws, and what's the tradition of those laws being upheld as sort of an evaluation for this law. And that's sort of what they're leaning towards, which could have all sorts of implications for future gun cases if the court chooses to adopt that as a binding standard for gun cases going forward.
Right, because the criticism has been up to this point that while Heller was a landmark decision that established for the first time an individual right to keep and bear arms that extended at the very least to inside your own home and the ability to keep the most popular kind of gun inside your own home, it didn't really set out a clear standard for how lower courts should review gun cases moving forward. And
that's right.
A lot of them kind of just did whatever they wanted has been the criticism that, lower courts have just kind of applied whatever standard they felt like applying during a given trial. So
sure.
Gorsuch was going through and Kavanaugh as well, and asking these plaintiffs and the defense, what should we do here? What should we set as the standard? And I think that says a lot because, as you noted there, that could have much further reaching implications than whatever they rule on New York's restrictive gun carry law, whether they strike that law down. I mean, that's still important. And I have a piece coming on what exactly that would mean if they strike it down and how many people will be affected, because it's still a lot of people, but there's only 8 states that have that kind of law. Whereas a lot of states have other kinds of gun laws that are going to come under heavy scrutiny from gun rights activists in the courts in the coming years here, especially if the Supreme Court says, hey, here's how you need to decide these cases from now on. And the text, history, tradition standard, which I believe you're writing an analysis piece actually on some of the intricacies with that, and
that's
how
right.
Some of the pitfalls maybe even for gun rights advocates who want to adopt that standard, because that's generally agreed what most gun rights activists want is the text, history, tradition standard. And like you said, interestingly, the government in this case, the federal government, said that that's also what they want. But there was one difference, right, between the two of them. What was it?
So the difference was in terms of the fallback. So if there's no historical analog to whatever law they're considering, or if they don't see the historical record as being properly comparable to the law at issue, the petitioners would like to see a strict scrutiny standard applied, which means that whatever law at issue has to be very narrowly tailored to whatever the government's compelling interest is. So in a gun case, obviously that's public safety, right? So the government would have to show that their regulation is very narrowly tailored to achieving those ends. And, in practice, that basically means the government loses. So the government, their argument was, no, it should be intermediate scrutiny if that's the case, in which case it's kind of back to square one where judges kind of decide on the fly. It's more of a policy judgment, which is what Kavanaugh's critique of that whole situation is.
Right, because Kavanaugh spoke up even when strict scrutiny was suggested by the plaintiffs, by
Right.
Paul Clement, Kavanaugh spoke up and said that creates dangers in using balancing tests, which is something that Heller had said. The court had
Right.
said in Heller they didn't want to use balancing tests because the Second Amendment is a core constitutional right and it shouldn't be balanced against government interests because it's too important.
And he reiterated that in his Heller 2 dissent, the famous Heller 2 dissent. He made the same case. And, this is where we kind of get to see why gun rights advocates like this approach so much, because he gave a pretty spirited defense of why an assault weapons ban would be struck down under a text, history, and tradition standard.
Right.
So that's where you see a lot of the hope coming from for gun rights advocates.
Yeah, because a lot of modern gun laws would not survive a text, history, tradition standard, most likely. Although, as I think you're going to get into in a members piece here soon, there is some wiggle room in that standard. But
Sure.
it'll be interesting to see what exactly the court does. It does feel like they're leaning towards coming up with an actual standard for lower courts to follow this time around so that their rulings aren't more or less ignored by some of the lower courts, which was the big critique from gun rights activists at the very least over the last decade or so. And even from some of the justices themselves. Thomas has been very vocal in how he thinks the court has fallen down on the job in terms of protecting the Second Amendment and allowing the lower courts to do more or less whatever they feel like doing.